The Supreme Court just handed down a ruling that has gun stores across America looking like they've been hit by a locust swarm. And if you haven't heard about it yet, you're already behind. Entire categories of firearms that were buried under decades of legal restrictions are now flying off shelves faster than retailers can restock them. Today, I'm breaking down the Supreme Court decision that just changed the game for gun owners nationwide. Before we get into it, smash that subscribe button right now and turn on notifications. The legal earthquake nobody saw coming, the legal earthquake nobody saw coming. You know how every gun law challenge for the past 90 years has been met with the same response from courts? The government has a compelling interest in public safety. Case dismissed. That playbook just got shredded. The Supreme Court ruled in a landmark decision that fundamentally rewrites how every single gun restriction in America gets judged. From this point forward, and the standard they set is so strict that legal experts are saying half the gun laws on the books right now can't survive it. Under this new test, the government can't just claim public safety anymore. They have to prove that the specific restriction they want to enforce has deep roots in American history, going all the way back to when the Constitution was ratified. Within 72 hours of this ruling coming down, 14 separate lawsuits were filed in restrictive states challenging everything from magazine capacity limits to assault weapon bans. And every single one of them is citing this decision as the legal hammer that's going to break those laws apart. But here's what almost nobody is talking about. The part that's going to affect you personally, whether you own guns or not. The buying frenzy that broke records. Gun store owners are reporting sales figures that make black. Friday looked like a slow Tuesday afternoon. One major retailer in Texas processed more firearm transactions in the first week after this ruling than they did in the entire previous quarter. And they're not alone. The FBI's National Instant Criminal Background Check System, which processes every gun sale in America, recorded over 2.1 million checks in the 10 days following the Supreme Court decision. That's a 340% increase compared to the same period last year. And it's not seasonal. It's not a holiday rush. It's purely driven by this legal shift. Firearms that were considered niche or specialty items, things that casual gun owners normally wouldn't look at twice, are moving at rates that have manufacturers scrambling to ramp up production. Dealers in California, New York, and New Jersey are seeing something they've never witnessed before. People are buying guns specifically because they think the window of opportunity might close if state legislators find a workaround to this ruling. But the most surprising thing about this surge isn't the numbers themselves. It's who's actually doing the buying. First-time gun owners are leading the charge. Here's a statistic that's going to shock you. 43% of the firearms purchased in the wake of this Supreme Court ruling are going to first-time gun buyers. That's according to data compiled from point-of-sale records across 12 states. And it represents the highest percentage of new gun owners entering the market since the pandemic buying surge of 2020. These are individuals who never seriously considered gun ownership until a Supreme Court decision made them realize that rights they thought were restricted or out of reach were actually constitutionally protected all along. Firearm training courses are booked solid through the next 4 months in most major cities with wait lists, doubling and tripling in places like Chicago, Los Angeles, and Boston, cities that historically have had low rates of gun ownership. The demographic breakdown is even more interesting. Women now represent 38% of these new buyers, up from 22% in previous years. And the fastest growing segment is people aged 25 to 35 who are purchasing their first firearm for home defense. What's driving this isn't fear or politics. It's the sudden realization that legal barriers they assumed were permanent just evaporated overnight. But while new gun owners are flooding into the market, there's another group that's been waiting in the wings for years, and they're making moves that are going to reshape entire state legal systems. The state-level legal avalanche. Right now, as you're watching this, there are 37 active federal lawsuits challenging state gun laws using this Supreme Court ruling as their foundation. That number was 6 just 3 weeks ago. Gun rights organizations that have been building legal war chests for years are now unleashing coordinated legal campaigns targeting the most restrictive states in the country. And they're not going after small regulations. New York's concealed carry permitting system, which has been in place since 1911, is facing its most serious legal threat ever, with plaintiffs arguing that requiring proper cause to carry a firearm violates the Supreme Court's new standard. California's assault weapon roster, which bans hundreds of firearms by name and feature, is being challenged in 3 separate cases, each one filed within days of the ruling. New Jersey's magazine capacity limit, Illinois' FOID card requirement, and Massachusetts' approved firearms list are all under legal assault right now. And the attorneys bringing these cases are using the exact same Supreme Court language in every single filing. What that creates is a patchwork legal landscape where gun owners in restrictive states might suddenly have access to firearms and accessories they've been banned from owning for generations. But there's a darker side to this legal tsunami that most people aren't considering yet. The compliance nightmare nobody's prepared for, Imagine you're a gun owner in a state where certain firearms have been illegal for 20 years, and overnight a court issues an injunction saying that law is unconstitutional. You can now legally buy that gun, right? Not so fast. State and local law enforcement agencies are caught in a legal gray zone where they're supposed to enforce laws that federal courts are saying are unconstitutional. But those laws are still technically on the books until the legislature repeals them or a final court order strikes them down. This creates a terrifying scenario. You could buy a firearm that's legal under a preliminary injunction, only to have that injunction overturned on appeal, making you a felon retroactively for possessing something you purchased in good faith. Gun shops in restrictive states are facing their own version of this nightmare, with many refusing to stock newly accessible firearms until they get explicit written guidance from state attorneys general, which in some cases isn't coming. The ATF has issued exactly 0 official statements clarifying how federal firearms licenses should navigate this mess, leaving dealers to make their own judgment calls about what's safe to sell. Some retailers are requiring customers to sign liability waivers before purchasing firearms that fall into legal gray areas, essentially saying, you're on your own if this goes sideways. But even in the middle of all this chaos, there's one group that's been absolutely silent. And their silence tells you everything you need to know about where this is headed. Why anti-gun politicians have gone radio silent. If you've been paying attention to how anti-gun politicians usually respond to Second Amendment victories, you'd expect them to be on every news channel right now promising new legislation to close loopholes and strengthen restrictions. That's not happening. Aside from a handful of generic statements about commitment to public safety, the politicians who built their careers on gun control have been remarkably quiet. And there's a very calculated reason for that silence. They know that under this new Supreme Court standard, any knee-jerk legislation they pass is going to get challenged immediately and struck down fast, which makes them look weak and ineffective to their base. Behind closed doors, according to sources in 3 state legislatures, Democrat-controlled states are working with constitutional law experts to craft new gun restrictions that might, and that's a big might, survive judicial scrutiny under the Supreme Court's historical test. None of these are guaranteed to work, but they represent an attempt to find constitutional workarounds rather than direct bans. The réalité is what's happening in Congress, where gun control advocacy groups have quietly pulled support from several high-profile bills because they know those bills are now unconstitutional on their face, and pushing them forward would just waste political capital. This silence isn't surrender, it's recalibration. Anti-gun activists are regrouping and trying to figure out how to advance their agenda in a legal landscape that just became massively hostile to restrictions. And that recalibration period is exactly what gun rights advocates are using to press their advantage and file as many challenges as possible before the opposition figures out a new playbook. Conclusion. So here's the bottom line. This Supreme Court ruling isn't just a win. It's a complete reset of how gun rights work in America. And if you're not paying attention right now, you're going to wake up 6 months from now wondering how everything changed so fast. Hit that subscribe button and turn on notifications so you don't miss a single update, because I'm tracking every lawsuit, every state response, and every new development as it happens.